Good morning, everybody. My name is Tom Romanoff. I am the Director of Technology Project here at the Bipartisan Policy Center. I want to thank you first for joining us today on this very important topic. What's next for Congress after Gonzalez v. Google? There was a good amount of time here in DC where all everybody could talk about is this Supreme Court case. And we have a decision that was made in the case and what it means for next steps in Congress as they continue to grapple with issues around Section 230 and algorithms and especially AI currently. So joining me today are some of the experts in this space, and I'd like to quickly introduce them. We've got Underpin Chandler, who's a professor of law in Georgetown here in Washington, D.C. He led the Internet Law Scholars amicus brief in the case itself. He's an expert in global regulation of new technologies and an author of books like The Electric Silk Road. Next, we have Eric Goldman, who is a professor of law at Santa Clara University. He also did an amicus brief in the Gonzalez v. Google case, and he co-directs the law's High Tech Law Institute and supervises the privacy law certificate, and he's been working in this space for about 30 years now. We also have Jeff Kosov, who's Jeff is a professor of cybersecurity law at the U.S. Naval Academy in Annapolis, beautiful place. He has authored things like the 26 Words, Cybersecurity Law, United States of Anonymous, and coming up pretty soon to look forward to his book in October called The Liar in a Crowded Theater. And then finally, we have Shane Tews, who is coming from another great think tank here in Washington, D.C., the American Enterprise Institute, where she is a non-resident senior fellow. She's also the president of Logan Circle Strategies. So thank you for my guests for joining today. And we're just going to start off with kind of a round robin question around, what your thoughts are on the court's decision in Gonzalez v. Google, and what did you think? And I'll start with Shane.
So as the non-lawyer on this call, it was the first time I'd actually listened to a Supreme Court oral argument. I was fascinated by the entire process. And I was very actually relieved to feel like the Supreme justices knew they'd taken the time to learn quite a bit about how the technology worked from a societal perspective, but there still was definitely some reticence to understand how the technology actually worked, which is probably healthy. But it meant for a lot of people that the internet will continue to be a place of freedom of expression. Somebody who's been in the technology side of this for a long time, there's always been a concern that we flatten the internet down to just a big smarmy sales place, which is terrible for everyone. But we're also continuing to have the concern that the courts create the rules rather than Congress on this very important issue. So still a lot to be seen in this space.
I'll kick it over to Eric. What are your thoughts on the case?
This was had the indicia of being the big battle royale over the future of Section 230, and we really didn't get that at all. We got a non-opinion from the Supreme Court on the topic, kicking the case back down to the Ninth Circuit, which I'm relatively certain will dismiss it. From my perspective, I think it was the right move for the Supreme Court to show appropriate deference to Congress. Section 230 was created by Congress. It can be supervised by Congress. And the Supreme Court really, I think, showed the appropriate restraint or deference towards the case by letting Congress speak up if it has something to say. Obviously, Congress has discussed Section 230 extensively. I know we'll talk about that later. And so the Supreme Court stepping aside, I think, will let Congress do the work that it needs to do if it so chooses. I don't know how much we're going to talk about the Tomnet case, but I honestly think the Tomnet case will be a pretty important case for the future. It addressed a very similar issue. When is a service liable for providing services to third-party customers? But the ruling addressed the common law aiding and abetting principles that cut across a wide range of legal doctrines, not just the ones that might be governed by Section 230. So I think that what really happened is that we got the status quo preserved on Section 230, and we got a pretty important decision on other common law principles that will ultimately be internet service favorable.
That's a great point, Eric. And I want to expand the question, and if we want to go back to some of the other folks that we're talking in a minute as well. But in addition to what do you think about the opinions of Google v. Gonzalez, what do you think the impact would be to NetChoice versus Paxton Moody, and some of the other kind of Texas and Florida media laws. And I'll kick it over to Anupam for a response. Anupam, I think you're.
I want to echo.
There you go.
I want to echo what Eric just said. That I think that this was going to be the battle royale around Section 230. You had an enormous number of amicus briefs filed in the case, something like 80 or so amicus briefs, most of which I think were surprisingly, on Google's side of the case. They didn't want to see Section 230 rewritten by the courts. This was something that Shane had mentioned in her remarks as well, which really was the invitation to the court by the plaintiffs in this case. I want to begin by noting that the facts of the case are god awful. The terrorism that the plaintiffs faced, it was of course very, very real. The question in the case was whether or not it made sense to hold the internet companies liable for the terrorism they experienced. And so the theory of liability in the case was ultimately very, very indirect, that there were videos that were online that might have theoretically kind of caused people to commit more terrorism. And that might be the terrorism that these people experienced. As was written in the Tomna case, in the 9-0 opinion in Tomna, the court there embraced the idea that that the plaintiff's theory of liability basically said that if there were terrorism committed anywhere in the world, that Google, Facebook, and Twitter would be liable. And that was a kind of world that doesn't make sense as a matter of law. And then the questions for free speech that would arise, the implications for free speech that would arise if we moved into that world would be really, really stark. And we can talk about that more. But I think that those are the critical cases, and Tomney really kind of has implications for the Section 230 analysis going forward.
For sure. And I would love to dive deeper into that as we get going. I want to kick it over to Jeff to get his response on some of these on the case and how they're connected to some potentially ongoing cases and further deliberations on Section 230.
Sure. So I don't have much to add other from what's already been said. I agree with everything. I went into listening to the oral arguments very worried because I didn't see any good outcome of the Supreme Court interpreting Section 230 in this specific factual scenario, and I had thought they would, but during oral arguments it kind of became clear that they really didn't want to do that. Justice Kagan, I think, really hit the nail on the head when she said, we're not the 9 greatest experts on the internet. Why isn't this something that Congress should be dealing with? Which I think is exactly spot on. So that was pretty encouraging. There were it did seem like part of the issue was there were some justices who actually were fairly sympathetic to the plaintiffs for good reason. I think especially Justice Jackson. But I think they kept trying to find the line that needed to be drawn from the plaintiff's attorney, and they weren't really getting that. It wasn't really clear what does it mean to not cover recommendations. What does that exactly mean? So I think the outcome was the right one. I agree with Eric that the aiding and abetting portion of the Tomna opinion could actually have a very large impact far beyond ATA-related cases. My one disappointment would be that I had wished, and this was partly due to the fact that it wasn't all that well briefed by the parties in Tomna, I would have liked to see the First Amendment issues addressed as well, because I think that would provide a bit more clarity in the chance if Congress were to change or eliminate Section 230, we'd at least have a more solid and clear backstop that sets the rules. So that's what I kind of hoped we would see, but we might get that in future cases. The one other thing I'll say about Tommy, the one thing that did concern me was there was some language about how, of course, these algorithms are agnostic. That was hinted at a few times, and I'm just a little worried that might be just a harbinger of what's going to happen in the net choice cases if the Supreme Court grants cert.
So pulling on that thread a little bit, you mentioned Justice Jackson's kind of opinion on this, and she wrote an opinion piece on it in which she said, if the facts of this case merit this decision, but if there were different circumstances for future cases, it might merit a different decision. Any insights as to what she meant by that?
It wasn't completely clear. I don't know if she was talking perhaps about, there have been some products liability related Section 230 cases. So I don't know if that was what the discussion was, or if it was about a broader interpretation of Section 230. This just wasn't a really great vehicle for that sort of interpretation, but it did leave me wondering exactly what scenarios she was thinking of.
Okay. Yeah, and that's an interesting, perspective on the First Amendment issues. I want to get back into that, but as it sounds like we have consensus among everybody that the Domina case was much more kind of, as they wrote it, consequential down the line, and kicking back Section 2 issues to Congress. As you all know, Congress is dealing with generative AI, whether that should be considered under Section 230. Howley and Klobuchar just came up with the bill yesterday saying no Section 230 for AI generative content, barring liability protections for anything on that front. But I'm curious as to what questions do you think arise from Section 230 applies in the whole kind of ChatGPT, Bard, Dolly type of thing, and should Section 230 apply to some of this content as we're starting to move into not just what Section 230 means for content moderation, but what does it mean for AI? And if I can kick it over to somebody, or somebody want to take it first.
Well, I think one of the key things that we learned from this case is that it's a lot of people just thought of Section 230 as the internet protection law. They didn't really know the details of it. And so I think we've learned a lot more about what Section 230 does and doesn't do, which is really related to a specific, audience of policymakers, which are, members of Congress and their staff as they're ruminating on this. Klobuchar and Hawley putting out a lot. I mean, they're unhappy. They're about a lot of things, and it all goes to the internet is allowing people to have opinions out there that either do or don't make them happy, and they're threading it into every piece of legislation that they're putting out there. So that is not shocking, but it means that we need to be more thoughtful about how we're that people are realizing the importance of the internet, and that you can't have people's little angry foibles be pushing legislation that's going to do things like decide how we're going to use generative AI for the future. So I feel like we need to actually double down on informing and educating what the 230 can do. But if we do want to be amending something, I don't recommend amending. I think that we really need to be thinking about new digital laws. We need to be thinking about how we're using analog laws in a digital environment. And we're definitely going to have a lot of time to think about that with things like generative AI.
Yeah. And Professor Goldman corrects me. It was Blumenthal, not Klobuchar, who introduced this bill along with Hawley. Thanks for the correction. But Eric, did you have anything you wanted to add? I know you've spoken in the past around a specific Section 230 type of bill for AI.
Yeah, a few thoughts about this. Obviously, everyone's talking about AI because we're, I think, on the cusp of some major watershed changes in technology and possibly in society accordingly. I think ultimately there's a lot of good news there, but because we're in this techlash downdraft, everything about AI instantly comes with the presumption that the machines want to kill us and there's never going to be any good outcomes. And so all the discussion about how we ensure that AI technology can develop in a pro-social way is being swamped by the paranoia and fear that AI is just, is just a ruthless human killer. in terms of how Section 230 applies, I personally see this as actually quite complicated and not easily distilled into a single statement. Three things that I can say with confidence or reasonable confidence: if generative AI is republishing third-party content verbatim, it ought to qualify for Section 230 unless Congress amends it. If generative AI is creating content that exists nowhere else, I don't think Section 230 ought to apply to that. In which case, no bill is required. That would just be the standard law. I think the complicated area is when generative AI summarizes third-party content and relays the gist or the meaning of that third-party content, but doesn't use the precise words. And I think that's an unclear topic. If you look at what's going on in Europe with the AI Act that's working through the European process, that's an AI killer bill. Europe is going to take a stance. They want AI dead. And so is that going to be the future here in the US? Is that what we're going to do? Are we going to model ourselves after Europe? Are we going to go and define a more open-minded stance, knowing that here in the US, if we don't provide some kind of shield from liability for AI, almost certainly the regulators and the plaintiffs' lawyers are going to overrun it and eliminate it from our country, whether or not we take any further steps. So to me, I think there's a real battle for the soul of AI going on right now in the regulatory circles. Do we think it's actually a net positive for society? If so, we probably have to do more to protect it legally from the fact that everyone's trying to regulate it in the tech lash.
Yeah, certainly the AI doomers, as they're called, are dominating the narrative currently around artificial intelligence and the need to regulate. And there's almost a vacuum of kind of the positive use cases that are being thrown around, that at least that I've seen in my bubble that I live in. But I wanted to also, Anupam or Jeff, do you have any response in terms of Section 230 and how it applies to generative AI?
So I think Eric's description is exactly right, that it depends on the exact use. But overall, the main use of generative AI to generate new content is not covered by 230, because if you are someone who helps produce that content, then you aren't in fact covered for the content that you've helped produce. So I think so in other words, the bill from Blumenthal and Hawley kind of denying 230 protections to generative AI is unnecessary, because 230 already does that, already doesn't reach that far. And I don't think courts would find that. The main thing I want to just point out also is that there is need for guardrails. I think everyone agrees that there are needs for guardrails. The question is, what should that law look like? I'm not entirely sure that the AI Act is a kind of AI killer within Europe. They definitely do not believe that. They've designed it, at its heart, it's a risk assessment process, not categorical prohibitions, except in very narrow domains, all of which have exceptions built into them as well. So I think we will yet see what exactly the AI Act means in practice. It's certainly going to be a lot of work for companies. I think that's all true, but I'm not convinced that it's an AI killer in Europe.
Jeff, any thoughts?
Yeah, and I should just give the disclaimer that I'm speaking on my own behalf and not on behalf of the Navy or the DoD. That said, I fully agree with Eric's analysis of, does 230 apply to AI? I mean, people want a simple answer, yes or no, but it depends. And we have a large body of case law that shows how courts will analyze that. And I think that it will be very case specific. So I agree with everything that's been said. I'll just add that of the past 10 media interviews that I've done regarding the internet or 230, almost all of them have been about this question. And while I do think it's an important question, I think AI has a lot of potential. I think there's a lot of really fascinating issues. I also think there are other issues out there. I think we have the DSA about to go into effect, and we have an unelected bureaucrat in Europe who's going around threatening platforms about disinformation. We have the net choice cases, which I don't see how the Supreme Court avoids taking them, which can really determine the entire future of internet law. So while I love thinking about these AI related issues, and I think they are important, I worry that we're perhaps focusing a bit too much on that and not on these other really imminent issues here.
Got it. So it's almost like there's this hypothetical space that we're all kind of germinating on, but in your opinion, there's these very real space of pending cases that will reshape how we think around internet law that we should really be focused on. Shane, you
yeah, I can just add, so I think, and this isn't specific to 230, but in general, I'm always concerned. I always say I want to talk to the engineers first and then the lawyers, because the engineers are want to create new, interesting things. And if you let the lawyers get in the room too early, they create a much more narrow deployment at an early stage, which would limit a lot of technologies. And that's a big concern with AI, is if we start to cabin off the opportunities and the probabilities too early because of risk, because we have the lack of liability protection, we won't get to see a lot of things that that technology could do. And to give you a good news story, I did a breakfast this week with Dr. Laura Jedi from Cleveland Clinic, who created a COVID tracker that they were able to prioritize cases by realizing, as people were coming in, the symptoms, that which ones were more severe, and so they could get to those patients first. And it was an interesting discussion, because she was like, I was having to thread the needle through, FDA regulations around clinical trials, but luckily there's kind of what I'd call a break the glass, that she was able to say, okay, this is a moment in time where I need to really pull as much information together as possible. And they were able to see what was coming in, and, the words that were being used by people about their symptoms were helpful in them helping do, diagnostics. So those are the kind of things that I would hate to see regulation curtailed too early, because we were just worried about liability. So I think there's an interesting balance that we're all going to be, delicate balance we're going to be watching go on with AI.
Yeah, I do. That's a great point, and thank you for pointing that out. I think that there's a need to not only address some of the risks that are out there in artificial intelligence, which a lot of people are doing in the media cycle and through academic studies, and through real case scenarios. But there is also a case to highlight some of the positives that AI can have early on. To your point, I always get asked, are you worried about AI? And I said, yes, this is a use case where it can go off the rails, but here are two other use cases where it can be beneficial to society, and trying to change the narrative in that front. We do have a question from the audience. It was retracted, so I'm going to ignore it, but switching gears a little bit into what this means for Congress, which I think is what a lot of the folks want to know. As Congress has debated a number of the Section 230 amendments, content moderation issues, there's this idea of clarifying what content moderation would mean versus transparency obligations. And so what extent do platforms should be accountable in the regulatory space? And what role should legislation play in potentially facilitating this accountability? And do you see any kind of the federal or state level bills that might be promising in that space? And I'll start off with Shane.
So I think one of the things that we've been trying to track while everybody's tracking legislation in the states and federal is the actual issues people are concerned about, and then pointing out that a lot of them are not Section 230. They don't need to actually amend Section 230 to solve the problem. And an example would be like the DMCA, where very early on they were like, okay, we have separate laws that we manage through this, and so pointing that out and seeing if there are areas that are really just kind of anxiety and fear about where the internet is headed, that we can think about processing that and not, bothering to ruin a perfectly good law in Section 230 to do that. So that's a lot of where I'm spending my time, but it's trying to filter through kind of the fear bubble while I'm letting the brilliant lawyers that are on this panel discussion, figure out all the legal angles, because you guys are doing a great job. I'm not going to step on that.
Great. So I'll kick it over to some of the lawyers. Jeff, do you have any thoughts on kind of to what extent, government can facilitate a better, law besides Section 230 or amending, or leave it alone? What are your thoughts on it?
Yeah, so my book came out, I guess, just a little over 4 years ago about Section 230, and that was right when it suddenly started becoming something other than an obscure tech legal issue. And so it's been an interesting 4 years. And one of the things that I do fairly regularly is talk with really any congressional staffer or a member of Congress who wants to talk with me. It's really a mix of people across the political spectrum. And I will say that before we talk about accountability and what the goals are, which I think have a lot of constitutional issues both ways, we have to look at what we want the internet to look like. And when I have these talks, I let them guide it and hear what they think. And I hear very different visions depending on who I'm talking with. I hear from some people that, we want the platforms to do nothing but block illegal, constitutionally unprotected content. I hear from other people saying we think there's a lot of really harmful stuff, even if it is First Amendment protected, and we want to figure out how to use levers such as Section 230 exceptions to get them to moderate it. And I think on both sides of that, I think putting something in the law would have big First Amendment issues, and I think we're seeing that play out with the Florida and Texas laws. But we can't even get to the step of what approach to take because they're radically different views and visions. So I don't see very many. I really can't think of proposals that would have enough support across the aisle. Just based on what I'm seeing, that would even be able to pass because of these different visions.
Different visions, different ideas, but I want to kick it over to Anupam. Any insights as to if there's anything that's promising out there?
So I think the question is, what do people care about? And I think this has been an issue that you've raised, Tom, and Shane's raised. What do people on the ground really care about when they think about the internet? What are the problems that they see? What are the things that they like about the internet? Some of the bills, I think, currently in Congress related to Section 230 would actually not really fix the problems, but also kind of reduce what they like about the internet. So one of the things that people like about the internet, I think generally, is the fact that they can hear lots of different voices. And I think some of the bills in Congress would actually make that more difficult. In the Gonzalez case, Microsoft submitted briefs that said, hey, look, even LinkedIn is going to be affected by Section 230 changes. So if the court had gone and narrowed 230 scope, they said, people who are automated systems might erroneously kind of push as identify as plausibly problematic in terms of future liability. We might remove them from our platform entirely, and if a liability regime that's very, very strict would cause us to get rid of a lot of people who may actually be doing perfectly legal things that they should be able to find jobs for. And so there are real world consequences of 230 reform that I think that we need to pay attention to. And you saw that from lots and lots of companies like Reddit and Wikipedia filing briefs in Gonzalez. So you saw that Section 230 has a ton of friends out there, actually, because large and small companies depend upon 230. Even newspaper publishers, to the extent that they offer online comments, often depend on 230. So 230 is a broad shield for lots and lots of entities online, not-for-profits, et cetera, et cetera. So I think we need to be cautious about doing that. However, I think that much of the energy is now shifted to kind of children's protection online. There, we've seen lots of bills getting passed across the country in state houses. We're going to see, lots of efforts at the federal level. And I'm not sure what are the best interventions, but I'm worried that some of the interventions are are too onerous for the internet, and that would actually kind of Disneyfy the internet more generally. And so I think there's going to be a lot of kind of controversy about whether or not the internet should even be available for kids under 18 under some of these approaches.
Yeah, and I know some of our panelists have discussed, whether restricting the internet for age verification or age gating is a violation of First Amendment rights for those children. And I think that there is something to be said here, because what I'm seeing is a pending clash between this epidemic of adolescent mental health issues, somewhat correlated to, or at least thought of as, a negative consequence of social media use. Also, you can see the use case of social media getting a lot of these kids through COVID by providing a sense of community online. So I'm not advocating one way or the other, but you're seeing a lot of the legislation, especially at the state level, but also some federal level bills trying to restrict access because of perceived impact to adolescents and their mental health. So what it would be, and I want to kick it back to Anupam again, what would be something where, is it a transparency thing where we need to get more information on what impacts might be there and try to find correlations that, or causation, whatever it might be? Or is it something where, a completely different approach is needed?
Sure. So there are platform transparency bills in Congress now, which might make sense. I think Eric has written kind of provocatively about the constitutional constraints on even transparency laws, which is very interesting, and I think we have to think hard about those questions. But I think, and maybe some targeted rules, guidance on, do we think that kids are online too much? Should there be defaults that kick them offline on games and other things? Are they? I don't know, but I think that we need a serious. So one of the things that the social media and mental health crisis, I am confident that some people are harmed by social media. I don't doubt it. But others are also helped by social media. So how do we figure out when social media is being helpful and when it's being harmful? I'm not sure. So I think lots of people who might not do well, who find it hard to engage in real life, may find a community online, and that is actually a kind of way to kind of save themselves in the sea of their schools or family circumstances that might not be healthy. So I think we ought to keep that in mind as well.
Yeah. So I'll kick it over to Eric. Kind of, we have a couple of rabbit hole questions points that we'd love to get your opinion on, and then kind of pulling it back if there's any, original question, which was, is there any legislative proposals out there that look promising in your mind?
Let me start with the conceptual question first. From my perspective, I feel like there's a pretty sizable disconnect today between what constituents want and what politicians are doing. Both of them support this vague notion of stick it to big tech. But when you look at what the policymakers are actually proposing and the real world consequences it would have for their constituents, because like, no, don't do that at all. And so, for example, age verification is, I think, a good example of the disconnect. In theory, the idea is let's give kids greater protection online. Constituents say that sounds great. The reality is, every single time you click on a link, you're going to be asked to verify your age, and you're going to have to provide private, sensitive information to websites you don't know yet and don't yet trust. And people are like, that's horrible. Who would ever think that's a good idea? And of course, that's going to be the law here in California in a year. There's other bills throughout the country that are adopting the same model, and Congress is debating the same model. And I just don't understand how there's such a disconnect between the politicians thinking that they're doing what the constituents want, they're sticking it to big tech, but actually what they're really doing is making the world worse for their constituents in ways that constituents are ultimately not going to tolerate. I don't know how to bridge that gap. I don't know how to bridge that divide. And I think that the overall emphasis on protecting kids online is kind of like a politician's cheap shot. It's a go-to. It's what started the first round of regulation here in the U.S. Back in 1996, Congress enacted a law that required age verification to keep kids safe online. And we're like doing it all over again. That law was struck down. Congress tried again in 1998, passed another law. That law was struck down. And now here we're like, let's just try it all over again. And to me, I feel like this is just a reminder. This is not a new issue. This is not an issue where the policymakers are actually being all that creative or innovative. They're playing to their audience's emotions, not to actually solving whatever problem they think they want to solve. So in terms of positive reforms, I really think the question comes, as several of my co-panelists have said, what problem are we trying to solve? And what we find is that so often the policymakers can't answer that question precisely. They have these very vague notions of what problem they're trying to solve, but when you test the solution to the problem, the entire solution falls apart. And just as another example, with age verification, the idea is here in California, it's supposed to protect kids' privacy. The way that kids will be determined to be kids and not adults is by revealing incredibly personal, sensitive information, either government documents or in subjecting them to face scans. And so if the problem was enhancing kids' privacy, the solution of age verification is actually pushing us in the exact opposite direction. And that's why I find it so hard to support any of the regulatory proposals at the federal state level, because that kind of counterproductive outcome is riddled throughout all of them.
Excellent. Thank you, Eric. Shane, it sounds like somebody yeah, go for it.
Working on the child online safety issues since the early 2000s, we've always had the challenge of identity management. And, so we kind of just avoided it. Like we just said, okay, we're just going to hope that parents make good decisions as to what they let their kids do. And we didn't really put any guidance around it. And now the parents are just like saying, state law or whatever, go figure this out, rather than taking some responsibility for it. And there are ways to do legal guardian permission or parental permission. This came up during COVID when all these kids went online and they were really forced onto devices for educational purposes. Some of the companies that were doing the validation were immediately able to sell that information to third parties. And we didn't step in as, kind of a concern to stop that. So there's layers to this that I have a concern with. And part of it starts with the education system, that they were happy to take on something that lowered their cost and immediately sold information on children, or, allowing them to go what they were supposed to be doing, educational elements that would just ride right into some gaming entity. So I think in general, we have had the wonderful several decades of being anonymous online. We're going to really have to start to do more validation of who you are, not only with kids, but just with humans in general. And part of that, we are seeing the advent of a better single sign-on process. So along with that, I take my preferences with me when I do a single sign-on. I also decide whether or not I want to be tracked. I like to be tracked. I like them to know what I want and don't want to know. It saves me time. And that's a choice that I make. So I think that's one of the things that we need to think about from a technological standpoint is, can we solve for some of these problems without these heavy-handed laws that are just going to be clicked through? I call them the mattress tag of the internet. You're just not supposed to take that mattress tag off. You're not quite sure why, but you just click through and say, yeah, I'm 18 or I'm whatever name it is. And is there any actual consequence once you've clicked through that? It's just a friction point. So I'm hoping we'll get smarter about that.
Yeah, for sure. I used to teach middle school computer lab, first job out of my career, and I can tell you it's very difficult to keep kids, firewalled into, at the time it was a school district, firewalled into their school district websites. I can imagine on a global scale, it's much more difficult. Before I move on to the next question, was there anybody who wanted to chime in?
I'll just add on the age verification issue. So last year I published a book about the value of anonymous speech, which probably means that I shouldn't write books about anything that I don't want to turn into a total disaster the next year. But I obviously am very concerned about the complete inability to be able to have anonymity online if these laws continue to be adopted. And I wrote something on the Daily Beast a few weeks ago on that very subject, and I got a lot of feedback from people who, some people said, oh, you can provide your government IDs and face scans and still be anonymous, which I have serious questions about. But some of the comments I got back were, why do we want people to be anonymous? Because anonymity on the internet is always bad. And I'm really worried that and one of the reasons I wrote the book was to push back against that, but I'm worried there's this sentiment out there that unless you provide all of your identifying information, you're up to no good if you're on the internet. And that's just not the case. There's particularly for vulnerable, marginalized populations, there are so many good reasons to be anonymous. There are teenagers in dangerous situations who are seeking support. There are domestic violence victims. There are political dissidents. And I'm concerned that part of the internet that's really been able to serve those populations will no longer exist because of these laws.
So collectively speaking, and please jump in if I'm summarizing this incorrectly, there's use cases both sides. The push towards, catering regulation to protect kids also has some problems with it from a First Amendment perspective, from being able to amplify people who have marginalized communities, or particularly folks that might be, to Eric's point, living in different states with different regulations, essentially. So as I move on, I want to kind of switch into what Section 230's major kind of how it got politicized, which was the political speech online, right? And so as we look at the impact of something like ChatGPT or synthetic narratives being easily produced, how do you think, as we're going into an election year, policy makers, media outlets have all expressed concerns on the impact of generative AI and the proliferation of election-related misinformation? What impact do you think this will have on the spread of AI and generative information? And what impact do you think it will have on how policymakers try to regulate this space? And that's for anybody who wants to jump in.
Well, at the danger of jinxing yet another area of policy, later this year I have a book coming out that argues against, in most cases, the government regulating misinformation and disinformation, regardless of the source, and explains why it's a bad idea to get the government involved as the arbiter of truth. Obviously, there are some exceptions to the narrowly defined First Amendment exceptions, but the point is they're narrow, and I'm very concerned. So I'm concerned about misinformation, but I'm also concerned much more so about the government seizing that power, those concerns, and grabbing more power. We've seen a number of misinformation related proposals that fortunately have not gone anywhere in the United States that would, for example, allow the Secretary of Health and Human Services to unilaterally determine what is health misinformation and then be exempt from Section 230 protections, which I just think is incredibly dangerous. And as a reason for why our protections are good, you just look to so many other countries around the world that have passed fake news laws in the past 5 years. And I mean, in Russia, if you refer to Ukraine as a war rather than a military operation, you could go to prison. And so I just think whether it's algorithm, whether it's AI or a human, I just am very, very cautious about saying, well, the solution is let's let the government determine what's misinformation.
So let me pick. If I could pick up on that, I think that's exactly right. So just look at what we're seeing with respect to the indictment of Donald Trump. The argument from some on the right is that the Department of Justice has been weaponized by the current government against its political opponents. And I think I'm pretty confident that if Donald Trump wins the coming election, he would indeed weaponize the Department of Justice against his opponents, partly out of vindictiveness, partly because that's, I think, his general view of how government should function. So imagine kind of an arbiter of truth at the governmental level. In either case, there will be pressure, whether it's a Republican or a Democrat, to find truth that is more congenial to that person's own personal political views, and that is a very dangerous thing. So I think we have to be. I think Jeff is exactly right that we do not want the government to be the arbiter of truth. We can certainly have the government pressing its view of the truth. I think that's important. But I think we want to be cautious about empowering government agencies, limiting liability shields, for example, as Jeff pointed out, when it has an official imprimatur of truth. And those are bad ideas.
Yeah. Eric, Shane, any additional comments there?
So mine's not a legal perspective, but I always worry that the internet is a very large mirror on society. And so you have this challenge where you've got, you have the moderator's dilemma. Do I take it up? Do I take it down? The transparency helps if you are looking for source information, but sometimes it's just, it's a group of people that have created an opinion. They're just positive at this point as a fact. And so, the government getting engaged in that is always going to be a very, it's always going to have the problem of, where is real transparency, because we have a lot of information out there now that people just take as fact that isn't factual. So we have to be careful where we engage on this. I don't see Congress getting any clear thoughts on this. That's definitely, it doesn't matter what a hearing is on anymore. Somehow this will come up in the middle of it. And it's part of our societal angst of what's going on now. Tom, you mentioned being, part of your bubble, and that's also a problem. Is the way that information just keeps getting pushed to you to make sure that you're getting confirmation bias to what it is that you want to hear. So we're looking at a much bigger societal issue than just a legal challenge around transparency of information and if it's accurate.
Yeah, for sure. And to be clear, I might be one of the ones who has a much larger bubble out there because I read all newspapers that I can, regardless of political slant, because I work at the Bipartisan Policy Center. I need to know both sides. But you're right. There is an echo chamber in some of these cases. Eric, I wanted to give you an opportunity to respond, or we can move on.
Just one last point I'll add to my colleagues' excellent and cogent remarks, what we really want is the internet services to be policing their premises against malicious or harmful misinformation that's not appropriate for their audience. And this is where I think the partisanization of content moderation has actually put many internet services into a deep freeze. They don't know how to proceed because they know whatever decision they're going to make about intervening or not intervening on misinformation is going to tick off one of the teams. And so because this question has become partisan, we've actually taken away, I think, our biggest lever to help manage information flows and protect against misinformation in politics and election cycles. And that's by hindering the ability of internet services to do that kind of socially beneficial content moderation. Not because they're legally prohibited for doing so, but because whatever decision they decide, they get this enormous partisan pushback.
So we're coming up close to the end of the program. We have 2 questions in the queue currently. I'm going to spend some time towards the end and answer those. Before I do that, I wanted to kind of get to this question of, and I think we all alluded to it, we're talking about the U.S. legal framework, but data doesn't necessarily live directly inside of a nation. Data flows don't know states too well. So there are impacts happening from the European Union's perspective, but I wanted to get everyone's opinion on this. But Anupam, I think you might be very well situated to kind of talk through what the actions on a global scale to try to address content moderation and their own intermediary law regimes have on kind of the internet as a whole, but how maybe policymakers here are thinking about it.
Jeff teed up the Digital Services Act earlier, and I think he's right that that's going to be a very substantial kind of a change to the internet. So it has lots of different procedural things that internet platforms, large internet platforms, must do. And it's really about making sure that internet platforms rapidly take down what is illegal speech under various laws. Now, there are various mechanisms for this. There'll be digital service coordinators in each of the EU member states. There will be trusted flaggers that are created. So a kind of large apparatus to operationalize content moderation online. My worry, in some sense, is that this can itself be weaponized. This has, what kind of the little whiff of something that says, "Hey, look, this digital service coordinator is kind of unhappy with this kind of speech being permitted on this platform," and the DSA has enormous penalties, up to 6% of global revenues of a company. So it's just it has a big hammer. So I think it's going to be an interesting. I agree with much of the kind of impetus behind the DSA, but the whether or not it's successful at improving the internet, which I think is always something that we should be striving for, is yet to be seen. But I think that's what I'm really watching for immediately. Obviously, the AI Act in Europe as well is going to be have significant implications as well.
And since you mentioned Jeff and his mention of DSA, I'll kick it over to Jeff. Was there anything you wanted to add to that?
Yeah, I agree. I think, and I had mentioned earlier, perhaps quite angrily, about the EU commissioner who is overseeing the DSA is kind of fancying himself as sort of the overseer of the internet. And there's sort of the precursor to the DSA, or part of the DSA, is this voluntary code for dealing with disinformation. Twitter recently withdrew from the voluntary code, and Commissioner Breton said something along the lines of, "You can run, but you can't hide. Our enforcement teams will be ready when the DSA goes into effect." And it's not a great way to think about how the EU is going to use the DSA. And when I've criticized that, I've gotten pushback saying it's just procedural. And it's like, yeah, but it's a procedure for taking down disinformation. So it's going to have, and as Anupam correctly said, it's 6% of your global revenues. That's not a slap on the wrist. That's something that will have a very real impact on speech globally.
Shane, Eric, anything you wanted to add there?
Yeah, the fines are what's driving the risk analysis now, which is maddening. And it's also, I was just making a list, and sorry for the acronym soup here, but we've got the DSA, we have the DMA, we have the AI Act, the Data Act, and GDPR, and then we have the advent of NIST 2, or the new cybersecurity rules coming on that are actually somewhat in conflict with each other. But you're having Europe really drive the next level of regulation as we go into the new things that are coming online with AI, but it just in general. And we're watching this administration is sending people from the Federal Trade Commission over to Brussels to enjoin the Europeans on their point of view, and then try to bring that back here to the United States to harm American companies. And that, to me, is just a hard no-go. I'm very, the precautionary principle, I can understand why they have their thoughts about that, but we have a different risk analysis that we do here in the United States. And I don't want to see the precautionary principle come onto the American shores and start questioning everything we do before we do it. We would never have the car if we were looking at the way that we're looking at some of these risk analysis around, the way we were doing artificial intelligence. So I'm very concerned about this. And I think the European attitude, it used to be you could kind of brush it off a little bit because they could never really organize themselves to a stage where they could, do significant harm. But this fine structure is making the companies really pay attention and decide that they're going to go take their legal departments over to Europe, and that's going to be the starting point of things. That it's also eventually going to be a real problem for raising capital.
Eric, last word on this question.
There's been a concerted effort across the United States to try to make arguments that internet services don't qualify for First Amendment protection as publishers. I've resisted those arguments, and my co-panelists have as well. And what we're seeing across the globe with the regulatory structures that are being developed to control what internet services do and ultimately what they say is a preview for what that world would look like here in the United States. In other words, the First Amendment may be our last defense against the government assuming that it can tell internet services how to do every aspect of their business. And if they can do that, they absolutely can and will control what content gets online and how that can advance their agenda. So to me, I look at the international environment as a cautionary tale. This is what's coming for us here in the US if we don't establish this foundational principle that internet services qualify as First Amendment protected publishers.
Great. And with that, I'm going to switch gears a little bit to the questions from the audience that we got. So the first one is, and this is for anybody who wants to jump in, thoughts on the significance of SCOTUS holding that recommendation algorithms are merely part of infrastructure, particularly in view of multiple comparisons of platforms to cell phones, mail, etc.
So I might take it up, but I'm sure Eric will have thoughts on this as well. There's a question here whether the Justice Thomas writing for the 9 justices of the court in Tomney. So the reference here is to Justice Thomas, who says these companies are essentially the infrastructure. And so they're like the internet itself. We wouldn't hold the internet liable when terrorism happens somewhere. That wouldn't make sense. We wouldn't hold a cell phone provider liable when a cell phone is used for as part of a terrorist enterprise. That's not what aiding and abetting liability should cover. So in that sense, there's a kind of infrastructure move. Some people worry that that move towards seeing this as infrastructure also has implications of seeing this as a requirement of being a common carrier for all kinds of speech, for all legal speech, and not moderating content and getting rid of speech that is against your community guidelines. And so the worry, I think, is a legitimate one. I don't think that ultimately the court, and so this is an issue that is raised in the net choice cases, because the Florida and Texas social media laws purport to say you can't have viewpoint discrimination if you are a large internet platform. And community guidelines are viewpoint discrimination. They say this is welcome, this is unwelcome. This kind of speech, pro-social speech, anti-social speech is unwelcome, and so that is viewpoint discrimination, unfortunately, from a legal perspective. And so the concern is, does seeing this as infrastructure mean that it can't discriminate on the basis of a viewpoint? I hope not, and I don't think ultimately that is it's not really a worry that I have.
Okay. Unfortunately, we have a hard stop at 11 o'clock, and it is 11 o'clock now. Anybody have a quick 10-second addition to that? No? All right, well, thank you so much. Apologies to the folks who submitted questions who did not get them answered, but I want to thank the panelists so much for your time today. This has been fantastic and a wonderful question and answer and dialogue. Look for some more. Thank you for your time, and please have a great rest of your day.
Thanks so much.